Kashmir to Delhi, there seems to be a UAPA connect today. A Delhi-based senior journalist Prabir Purkhasta's arrest under UAPA has been declared as void. The other, a Kashmiri journalist, Asif Sultan, has been granted bail in a 5-year-old UAPA case. Prabir Purkhasta, his arrest was on October 4th, 2023 under the draconian UAPA. He has been granted bail. The FIR against him accused him of unlawful activities, terrorist act, raising funds for terrorist act, conspiracy. More than 7 months later, the Supreme Court has called his arrest void or invalidating it. The grounds for doing this is important. Kapil Sibal, representing Prabir Purkhasta, argued the FIR was neither made available in the public domain nor was a copy supplied to him until his arrest and remand in violation of the fundamental right guaranteed under Article 22. Now, what is Article 22 of the Indian Constitution? That no one can be taken into custody without being informed, and no one can be denied the right to consult or be defended by a lawyer. Now look at these sequence of events as argued in court. Prabir was taken to special judge's residence at 6:30 in the morning without notice on October 3rd. They've claimed on insistence he was allowed proceedings via phone call at 7 in the morning. Unsigned copy of the remand was sent via WhatsApp to the lawyer with no mention of time or grounds of arrest, and the objections to the remand were filed before 8 in the morning itself. And why I am taking you through the sequence of event? Because that's 1.5 hours since he was produced before this special judge. 1.5 hours. And by then, the remand order was already passed and the lawyers were informed of the 7 days of police custody. One question, what was the hurry for the cops to not inform and still arrest or proceed with the remand request? They of course argued in the court that UAPA requires only to be informed, as against the sections under PMLA. But this didn't stand the test of the court. And then quickly, let's look at a case of a Kashmiri journalist, Asif Sultan, who has been granted bail by a special court in Srinagar in connection with a 5-year-old case under Unlawful Activities Prevention Act. The case pertains to an incident of rioting at Srinagar's Central Jail in 2019, when a group of inmates allegedly set fire to a few barracks and then stones at the prison staff, according to Scroll. The Public Safety Act allows authorities to hold individuals in custody without trial for up to 2 years on grounds of national security and up to a year to maintain public order. In its order on May 10th, this special court under the National Investigation Agency in Srinagar said that the police were given sufficient time of 72 days to interrogate Sultan in custody. In fact, the Supreme Court on Tuesday granted bail to civil rights activist and a journalist, Gautam Navlakha, who's facing charges under the Unlawful Activities Prevention Act in connection with the 2018 Bhima Koregaon violence case. The High Court noted that there was no material evidence to infer that he had committed a terrorist act under Section 15 of the UAPA. Navlakha, a human rights activist and former secretary of the People's Union for Democratic Rights, was initially arrested in August 2018. He was kept under house arrest, but subsequently sent to judicial custody in Taloja Central Prison in April 2020 after a Supreme Court order. He was later placed under house arrest again in November 2022 after the Supreme Court approved his plea, citing his advanced age. He has remained under house arrest in Navi Mumbai since of course, eventually the court intervened. Now, in all these 3 specific cases that I have mentioned, the journalists have not been acquitted. But the grounds of the court's rulings do raise some important questions. In fact, according to The Wire, 16 Indian journalists have been charged under UAPA since 2010. That's in last 13 years. So, a law intended to counter terror-linked acts is also at the stage of a debate on free speech and the right to one's profession, in fact, time and again. A law which Hyderabad-based Professor Hargopal once charged under UAPA in an interview with The Hindu claims has 97% acquittals. But in Supreme Court's own words, in UAPA, bail is an exception to the rule in the rarest of cases. There are so many aspects of all of this to discuss. And as we promise, we give you an all-round view. I'm being joined by Karuna Nundy, who's a senior Supreme Court advocate, Tehseen Poonawalla, who's a political analyst, Subhash Jha, who's an advocate, and Yuvraj Pokharna, who's a columnist. Thank you very much, all four of you, for joining us. Karuna, if I may come to you first. With what's happened in just the last 3 cases, let's start with perhaps the latest case of Prabir. Now, the first question that somebody like me, who follows cases after cases, but not with a legal mindset as a journalist, the first question that comes to me, the grounds on which the court did grant respite, if I may use that word, or call the arrest void. It doesn't mean he may not be arrested again on the same grounds, certainly. But the fact that the court had to go ahead and do that, calling this void, what was the hurry for law enforcers to go ahead and arrest it or follow the process in such a way? This is a high-profile case. It would have been under everybody's scrutiny. Everyone would have known that, including the law enforcers. So what was the rush? And is this rush only in Prabir's case, or is there a larger paradigm also that's seen?
Ms. Koshy, I think the point you make is a good one, which is that if you look at the number of accusations, for example, that are brought by the ED and the number of people that are convicted as a result of those accusations, the proportion is extremely, extremely low. And that is really quite troubling. I think the difficulty I find in this case is that it had to go all the way up to the Supreme Court to defend, to uphold Mr. Purkayasta's absolutely fundamental right. It's in the Constitution. Not only is it in the Constitution, the Supreme Court has clarified in the case of Pankaj Bansal that, and it was in a separate act, but the Supreme Court is very clear, and I think all of us should be very clear also that statutes like the Prevention of Money Laundering Act and the UAPA, which is a terror act, are what we say in the law are pari materia that must be considered together and equivalently. And that you have to give not just reasons, but grounds. When you arrest someone, I mean, intuitively, this is something that we as the people understand. That you cannot be arrested without really being told why you must be arrested, so that when you are produced before a judge, your lawyer can argue for that you need not be detained. And so, as you quite correctly pointed out, the strange haste with which he was produced before a judge at 6 a.m., prior to being given any details with regard to why he personally was being arrested versus abstract reasons, is something that seems to have gone through the court system in a way that the Supreme Court does not agree with and the Constitution does not agree with. And I think the citizens of this country should be a little bit alarmed about.
Subhash Jha, if I may come to you, you've heard Karuna Nundy speak as well, and my question is the same to you again. The whole point being, 1.5 hours, a remand report is signed. And 1.5 hours, all the accused in this particular case or the lawyer is just informed apparently after that. But there's no copy, there's no grounds which is given to the accused who has been arrested in this particular case. My question to you is, one of the big things that is debated against law enforcers who use UAPA is this, that there seems to be a rush. Two, there seems to be basis that does not merit UAPA. And then you have this whole point about how there seems to be far more acquittals eventually in these cases, years on, than what would be the convictions. So what happened with Prabir Purkyasta, and I'm saying this again, this doesn't mean he's acquitted in the court, this doesn't mean he may not be arrested, but is just yet again a blatant manner in which how this case seems to have been in a rush, like many would argue, in other cases as well.
See, there are few things which needs to
Subhash
be
Jha?
addressed to. First and the foremost, I find that the... Yeah, can you hear me? I find...
Yes, please, go ahead.
Having a first blush at the judgment of the first blush of the judgment of the Supreme Court, what I find that the principle which are analogous to detention law has been pressed into service for granting bail under UAPA, which in my humble submission, I do not agree with this proposition of law, because this is the judgment rendered by a 2-judge bench, whereas 3 judges bench and earlier benches have taken a view that if an order of remand, maybe an invalid order of remand, has been sanctified by subsequent order of remand, then recourse to Article 226 or to claim that it is an illegal detention, etc., cannot be had. Now, coming back to the facts of the present case, yes, you're right, that what was the hurry? The case is he was charged under UAPA. That means a very serious, a draconian law. So therefore, the law enforcing agencies were expected to be more vigilant. Why did you send the remand application as and by way of WhatsApp message to the lawyer concerned? Why can't a copy of the remand application be made available to the accused at the time of remand? Now, this is a practice, but I may tell you that I have been practicing law for the last nearly close to 4 decades. And this is nowhere, in no court possibly, a copy of the remand application is made available to an accused at the time of remand. We as lawyers have to beg rather. Now, I was the one who took initiative in the recent past and to force that why can't you bring a copy of the remand application and be made available to the accused.
Okay.
You are right. And I feel that something much more needs to be done with our investigating agency. They are required to be trained, they are required to be sanctified, and then they are, in this case also, they are required to be made accountable if there was a flaw in not furnishing a copy of the remand application, which of course seems to have been disputed in the court of law.
No, you know, it's so important when I hear both Karuna Nundy as well as you, Subhash Jha, because this whole aspect that comes out at this point is, this is one case where it has come out, he could, you know, Kapil Sibal was there to argue this in court. But what about so many other cases as stringent and as draconian in UAPA that seems to have just skipped a very simple thing, a basic thing, which is a constitutional right to any citizen of India? Tehseen Poonawalla, if you look at what's unfolding, over the last 13 years, studies have showed that there have been at least 16 journalists in India who have been charged with UAPA. Now, one, with grounds where the Supreme Court has in the past said, if there is any material found with you, it does not mean that you are a Naxal or a supporter of a Naxal just because you have some material passed with you. That's one of the judgments, that observations that came out from the Supreme Court. Secondly, and I'm making a very generic thing here, journalists would find, activists would find a lot of material with them. at any given point of time. Now, how do you go ahead and use UAPA in a way that would not infringe with one's right to one's own profession?
Thank you, Sneha, for having me on the show. Good evening to you, to my fellow panelists, and to all your viewers. The two lawyers have already made the legal arguments in this particular case. So let me go on to a slightly more worrisome aspects that seems to bother me both as a citizen and as a legal/political activist. There are two or three issues. You see, the courts today ruled that this arrest itself was illegal, procedure was not followed. That he may be arrested later for another day. But if somebody spent 7 months in jail for an illegal arrest, where does the buck stop? Who will be suspended? What action will be taken against this officer? Who did so? Can we get answers to those questions? Number two, I'd also like to comment on the honorable courts, and I'm deeply, deeply worried. You see, we have the tripod rule for bail. As long as the accused is not at flight risk, cannot interfere in the investigation or influence in a witness or anybody else, the accused should be given bail. Courts now have come up with a fourth parameter, gravity of the offense. And it's very scary. What is gravity of the offense? The whole reason I'm there for bail, is because I'm innocent until proven guilty. Who decides gravity in a bail hearing? Then the entire legal jurisprudence of your innocent until proven guilty has been turned around, like the first speaker spoke in the ED cases. So now you're guilty until proven innocent. But again, there's the double whammy there. If you're guilty until proven innocent, your case, the court doesn't go into the merits of your case. So the chances of you getting bail are very, very slim unless you have somebody who's a genius like Kapil Sibal or Abhishek Manu Singh, that too in the Supreme Court. How many people get that? So, these are issues that we should seriously reflect on as society. The courts should reflect upon it. Courts also come down again very heavily on one more thing. They said, look, they routinely deny bail. They say the accused is not cooperating with the agencies. Now, Article 20 makes it extremely clear that should not be, I have a right to not self-indict myself, a fundamental right. Why should I cooperate with the agencies? If the agencies have something against an accused, it is the agency's job to prove. Not cooperating is my job. Why should I? So all of these are very serious issues that we need to reflect upon. That's one. Number two, with UAPA and
Fair
ED,
point.
even with ED now they have copyright under ED. So if the government tomorrow does not like this conversation, some copyright violation, you can be under an ED law. And I think it's again time for courts to step in and ensure safeguard. And the only way safeguards can be ensured is erring officers can be punished. I'll just take one line more and I'll end. These officers are very bright IPS officers, IRS officers, IAS officers. They're very bright people. They're some of the best this country's produced. Their loyalty should be to we the people, not to 2 politicians or 3 politicians. They should remember this. When they behave like personal armies of politicians, they're doing a disservice to the iron service, the iron backbone of the country as envisaged by Nehru and Vallabhbhai Patel. These officers, IAS and IPS, should think about what they're doing. This is not how the bureaucracy is supposed to run. They can easily step up and say no. By submitting and becoming submissive to the government, they are letting down not just the country, they're letting down our freedom movement, they're letting down Nehruji and Vallabhbhai Patel.
Right. Very, very important points. Yuvraj Pokharna, if I can come to you, you are a columnist. Let me ask you this. Have you been worried? Is this a concern that so many journalists seem to be linked, charged with UAPA? Repeatedly so. Look at just in last 13 years, 14 years, just in a decade for that matter, you have 16 such cases where the journalists have been charged with UAPA. Now, this is huge in a country like India. And when you look at the nature of these cases, look at the allegations that are based and then eventually acquittals that may happen, and just the years that it takes for these acquittals or convictions if they have to happen. And then we have the editors' guilds in several cases, where they have said it's a harassment of journalists for that matter. They have gone on to raise very, very serious allegations, concerns over UAPA being charged against journalists, where they're saying government is using carrot and stick policy, brazen violation of freedom of expression. These are top journalists, top editors of the country who are raising concerns, saying deeply concerned about raids and detentions of journalists. So many of them have been raided, if you look just over the last 2 years.
Well, Sneha, first of all, this issue that concerns to the Mr. Purkayas is catapulting to a larger debate. There are multiple aspects to what you have just asked. For starters, you've spoken about Editors Guild.
No,
Frankly, if you ask me,
this
I don't
debate
give...
is not about Mr. Purkayas at all. It's not
Of
about
course, of course.
specifics of Mr. Purkayas' case. This
As I
debate
just said,
is
it is
largely
catapulting
about
to a
how
larger issue.
UAPA is being dealt with individuals. Correct.
Is
Correct. Please go ahead.
Is this the first instance? I mean, I have a lot of data and examples with me that may substantiate to the larger point that journalists have been browbeaten time and again, and not just for the last 5 years or 10 years. I have the history record starting from 1951. But this to me is a larger issue that is just about the accountability and the reforms that we need with regards to the judiciary. Just give me a couple of minutes more. Mr. Purkayas and his lawyers approached the Delhi High Court with a contention that they haven't been provided the grounds of the arrest while they were apprehended, not in written orders. And you know what the court said? The Honorable Delhi High Court said that UAPA does not mandate furnishing written grounds. And when they have finally approached the Supreme Court, although granted him a reprieve, but that too with a caveat that we are not commenting on the merits of the issue. We are just giving him a bail based on a recent order that we just passed regarding the Mr. Bansal, in which ED was supposed to give them in writing, the grounds of the arrest.
Okay.
This is, to me, I mean, an issue between judiciary. So that is why I said we need accountability from the judiciary and judicial reforms, because at one point of time, court gives one order, at another point of time, it gives another order. And who is at the receiving end? Not just the journalists, not just people
you're
like you
raising
and
a
me,
valid
but
point,
the
Mr.
larger...
Yuvraj. Let me just get in Karuna Nundy at this point. Yeah, you're raising a valid point, Mr. Yuvraj Pokharna. But Karuna Nundy, would you just see this as an issue only with judiciary's reforms that some would argue for, or is there a larger issue here, one, with the existence of UAPA, even with the reformed laws, as it were? There's a code of laws that has been reformed in this country, but UAPA has not been done away with. There have been changes to that, but still it exists. And second point, which everybody seems to be raising, is what is with bail being the rarest and an exception in UAPA cases?
So the responsibility, I think, honestly lies with us all. Because on the one hand, you have Parliament, which is, these laws that are being created that are, I think, a travesty against multiple constitutional provisions. For example, the fact that Section 43D of the UAPA and also provisions of the PMLA, in effect, in some cases, reverse the burden of proof. In another case, say that a judge can't really look at the material with the same level of appreciation when there are particular sections that are merely cited by the prosecution, which means that the statute, the law that our, the parties in power have made is something that allows the government to detain essentially whoever they want, right? And without the balance of the judiciary being able to step in as easily as they should under regular criminal law. Now, when we look at the judicial side, when we look at the judicial side, of course, there is the duty to uphold the Constitution, and there are various judgments by which the Supreme Court, for example, has said that look, regardless of what the statute says, Articles 21 and 22 are above this, right? So it has to be read into any law that any political party, any set of political parties may pass. But what is the difficulty? The difficulty is, for example, in the case of these journalists, the process is the punishment. Siddiqui Kappan, he was on his way to Hathras to report a case. And for no apparent good reason, he was, from 2020, detained for an extremely long period. And now he has multiple draconian offenses cited against him. So here, not only do you have citizens of this country being detained, and many of them actually getting acquitted later without any accountability of the system that didn't even follow the law as it currently stands, right? But also you have the death of speech, because not only is that particular journalist arrested, detained, and not released on bail, but there is a massive chilling effect across the board. I think even honestly, like having this discussion on your part must have constituted to some little degree an act of bravery, right? So we must question ourselves that as a society, do we have a right to know, the constitutional right to know that these journalists are meant to report things, quite apart from anything else?
Okay, Karuna Nundy, it's ironical that doing one's job, even in today's environment, may just be seen as an act of bravery. And I understand what you mean when you say that, but there's just so much of irony in that. Subhash Jha, if I can come to you, Karuna Nundy made some very important points here. Let's look at the facts. Now, none of us would want to justify any act of terror, particularly against the country. None of us, including me. And I'm not doing that. No journalist worth their salt would do that. The question is, how does one ensure that somebody who's been booked is not being booked for a job that needs to get done? Where is the safety net? Except after years, if not decades, when a conviction is done or an acquittal is done. You have lost your years. Your family members have lost so much. Now, I'm not making a blanket case. That's not what I'm doing. I'm asking you, where's the safety net?
What is the last question? Where is the... I'm sorry.
Where is the
could you please
safety
come again?
net?
See, merely because I'm a firm believer that irrespective of you cross Lakshman Rekha, there is a Lakshman Rekha drawn for everybody. You be a journalist, so what? But if you cross the Lakshman Rekha and instead of doing journalism, you indulge in terror activities or activities which is detrimental to the interest of my nation, certainly you could be prosecuted. Why only journalists? Lawyers are being prosecuted. Journalists have even been in the past murdered by gangs, not because they reported something against that gang, because they tied up with or hooked up with the other gang. And therefore, they were found to be passing information from one gang to another gang, or colluding and conniving with the police in passing the information. So therefore, there is a Lakshman Rekha drawn for each and every professional, every businessman. They are required to work with sincerity and ensure that they do not cross Lakshman Rekha. The moment you cross Lakshman Rekha, then the law will catch you up. Now, so far as the judicial reform is concerned, I am in complete agreement that we must have judicial reform. We must make our judges accountable for whatever they are doing. And I will be telling you something which will be shocked and horrified to know. I'm doing a matter where the maximum punishment under the Act could not travel beyond 6 years, and the man is languishing in jail for 7 years and 2.5 months. The go to the High Court, I go to the Sessions Court, High Court, and Supreme Court. Supreme Court sends me back saying that why don't you ask the High Court, directed the High Court to do it expeditiously. Nothing happens. So therefore, this is not a solitary case. Now, if we talk of law, law has to be sanctified as well, which would be made applicable to all the citizens equally.
No, you talk about a Lakshman Rekha, but in professions, and particularly in certain professions, particularly journalism as well, if you talk about Lakshman Rekha, there are Lakshman Rekhas that may be crossed, which may be seen as Lakshman Rekhas for entity A or entity B, but may not be really a Lakshman Rekha for the journalist in question. So then who decides what's the Lakshman Rekha? Tehseen Poonawalla, do you want to come in at this point?
Yeah, there are 2 or 3 things that are deeply worrying about that argument, and you rightly put, who's Lakshman Rekha? Let's say a journalist, let's say you, Sneha, decide to interview a terrorist, and which is your duty to do that, but one of the panelists thinks, hey, a Lakshman Rekha has been crossed. Who decides it? And this business of this line being drawn that should not be crossed is exactly what I spoke in my opening remarks. Gravity of the offense. Yet, gravity of the offense can only come in during the time of the case, but the process becomes the punishment. Now,
a journalist it may not even be about interviewing a terrorist.
I can't hear you, Sneha.
Interviewing a terrorist may be a stretch. It's about giving the space. It's about giving the airtime whatsoever about a terrorist who was convicted. That's a very, very different example. I'm not even talking about something as extreme as that.
I purposefully said, I'm purposefully talking about, say, a president or a prime minister of a country that is hostile to India. In the US, they interviewed Mr. Putin. So is that crossing the Lakshman Rekha in the US? So we have to be very clear, journalists, it is the duty of journalists. It is the duty of freedom of speech to bring information to viewers. That is your duty, your constitutional duty. Just as the constitutional duty of officers is to ensure that the law is upheld and the courts to ensure the constitution is upheld. Now, the fact is, when you say the Lakshman Rekha is crossed or the gravity of the offence is serious, but your conviction rate is as low as it is both in the UAPA cases and the ED cases, that shows you didn't have a case in the first place.
Absolutely.
So who spends the time in jail? Where is these journalists, is this activists? May I remind your viewers, I don't like the left. I think the left are loonies. I'm very clear. But a left loony called Gautam Navlakha, who I dislike, spent months and years in jail on the allegations that he was in cahoots to assassinate our Prime Minister. I was livid. I was livid at him. Turns out the email was forged, put in his computer, and a case now has been dropped by the NIA. Should IAS and IPS officers be doing this at the behest of somebody?
And the court is saying that they could find no act of terror.
Today, if this man is out, so today, if this man is out on bail, and that email on which he went in jail was a fake email, shouldn't the officer who planted it be punished? Today, if this editor is out on bail and he was in jail for 7 months on wrong procedure, shouldn't the officer who arrested him be punished? That is the question we are not asking ourselves. Again, I ask, what is gravity of the offense? Who decides gravity of the offense? This new jargon that's come in, gravity of the offense, or to add to it, you are not cooperating with agencies, is terrible, and it takes away liberty. And I don't understand how the triple test or the tripod test has now gone into a five test. That is very worrying for us as a democracy. Very worrying.
Yuvraj Pokharna, you were raising your hands. You had some point to make.
I think there's a lot of talk about
Karuna Nundy, I'll just return to you, Karuna Nundy. Karuna Nundy, Yuvraj was just raising his hands for a very long time. I'll just come back to you, Karuna Nundy. Give me a few minutes. Yuvraj Pokharna, go ahead. You were raising your hand for a while.
There's a lag here.
One thing, he was comparing apples with oranges.
You'll have to unmute yourself, Yuvraj.
Am I audible?
Yes, please go ahead. Yes, please go ahead, Yuvraj. Please go ahead, Yuvraj. Mr.
Am I
Pokharna.
audible? Am I audible? Audible to you? Yes, yes, yes. My dear
Okay,
friend
I'll allow my
Tehseen
team
was
to...
waxing eloquently, and he dragged in journalism, as in you, as an example. But he was comparing apples with oranges, and it was a very failed attempt at digressing. See, Mr. Purkayastha has been leveled with serious allegations of money laundering, of terrorism activity, and now the charge sheet has been filed. So we are not discussing any raw case, any case based on an FIR. The charge sheet has been filed by the agency. So I was not willing to wade into the allegations and arguments and the merits of the case. But my only and limited point is High Court says one thing. High Court says UAPA does not merit written documents. And what is the premise of the Supreme Court? The only premise of the two people bench of the Supreme Court is October 3, 2023 judgment. It's as recent as in the last 6 months that ED should furnish the grounds of arrest in writing to the accused. So, I mean, taking premises of an ED case with and juxtaposing it with a UAPA case, that is the only premise that Supreme Court has. What am I supposed to do as a citizen now? Hire this advocates like Kapil Sibal. What if I can't afford them? As Ms. Nundy said, process is the punishment.
Okay.
And there's no accountability within the judiciary.
He fought this case pro bono.
Of course, they'll fight this pro bono. Of course, they'll fight this.
Right.
One thing.
All
Will they
right.
fight
Okay.
for me?
No, I get your
Will they
point.
fight
I
pro
get your
bono for
point,
me?
Mr. Yuvraj Pokharna.
Will they
Karuna
fight
Nundy,
for me
if I
pro
could
bono?
have you in
They
at this
won't.
point, you wanted to make a point. You could also respond to what Mr. Yuvraj is saying.
Sorry, was that for me?
Yes, Ms. Karuna Nundy. Please go ahead.
Thanks. Look, there's a lot of talk here about Lakshman Rekhas, but we must be clear that the constitutional rights of each citizen of this country are in one very large aspect borne out by the Lakshman Rekhas of the state in restraining itself by the rule of law and the rules of procedure. So when those rules of criminal procedure are relaxed to such an extent that in the statute that they are allowed to do in their view and supported by two courts, pretty much something that is in violation, not pretty much, today the court has said that is in violation of even Article 22, something as basic as informing the person that they are arresting why they are being arrested. Then we have to ask ourselves that is it only the citizen that is being constrained by the Lakshman Rekha, and is the state being allowed to run amok? So the question today then is, as a number of panelists have said, that when even the rules that are actually quite broad, and too broad in my view, far too broad, in legislations like UAPA and PMLA, even those rules, when those are not followed, will the person's time in custody be compensated? Will the state apologize when they are ultimately acquitted? Some of them will be ultimately acquitted if we are going by the record. Unlike what Mr. Jha said, many of them will be ultimately acquitted, right? You cannot presume that just because they have been arrested that they have actually committed the crime. If you look at the record of the ED, for instance, will there be not just an apology, not just compensation, but also disciplinary action? I think it really has come to the point that there has to be clarity within the judiciary that is the balance for the legislature and the executive in this regard to step up.
Right. I'm afraid we're totally out of time. But there's one thing
if I
that
may have
I
a last
think
word.
everybody would agree.
Online.
Oh,
Yeah.
okay. Everybody does want to. One minute to each of you. Yuvraj, since
One
you
line. One
you
line.
raised your
I'll
hand
just
One
first,
take,
line.
go
I'll
ahead,
just
please.
take
Just
10 seconds.
one line.
I'll just take 10
Yes,
seconds.
yes.
10
Yuvraj
seconds.
first,
One
then
line.
Tehseen. Yeah, sure.
Since we,
Yuvraj,
since
go
we
ahead.
are all,
I'll also take 10 seconds.
just 10 seconds, yes. Since we all concur to the Lakshman Rekha concept, so let me tell you for the benefit of your viewers, the first Lakshman Rekha was brought in and drawn by none less than Nehru ji when he brought the first amendment in Article 19. That imposing reasonable restrictions on freedom of
Actually,
speech and expression.
that's actually a bit of a myth, but please continue with your point.
No, I'm done.
Okay.
I just wanted 10 seconds.
Yeah, I mean, that
that's
is
not
quite
true.
a
That's
stretch.
not
I don't
true,
think
but
that's a
yeah,
Lakshman Rekha.
that's not true.
One would
That's not true,
agree
but can
that
I
you
make
need
another?
to have quite common grounds
Yeah,
to
that's
even
not
enjoy
true.
one's
That's not
fundamental
really
right.
true, but yeah.
So, unfortunately, I can't agree with you on on that, Mr. Yuvraj.
Yeah.
But
Can I just make a point?
I leave that for you. Tehseen, go ahead, please.
Can I just make my point? 10 seconds. When Article 20 and Article 22 are violated, and routinely we are seeing they're being violated by agencies, Article 21, which is the mother of all fundamental rights, right to life and liberty, that is violated. And that is the absolute mother of all fundamental rights, from which emerges Article 19, Article 14, etc., etc., etc. Unless, and you know what, somebody like me, I'd rather have liberty than life. Honestly, I'd rather have liberty than life. And when you take away liberty, you're killing me in a very bad manner. So you're taking away my Article 21. I think we should think about this. It's something that we should all ponder about as citizens.
Right. Thank you very much, all four of you. Karuna Nundy, Tehseen Poonawalla, Subhash Jha, as well as Yuvraj Pokharna, you've added much to this discourse, this discussion in an extremely civil way. So thank you for being great panelists at this. One thing we would possibly agree on, this may be just about a rare case of bail, but ideally in a democracy like India, this has to be also a rare instance where this case is slapped against anybody, including a journalist, and must take deep, deep thought and recourse, and much thought and legal recourse really before going ahead with that. It's a right to one's profession, it's a right to dignity, and not just journalists, any citizen for that matter. Thank you very much to all of our panelists.